Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Today we're going to be talking about divorce and family law and addressing questions that have come in from viewers at questions@legalactiontv.com. Joining me once again, as always, is my co-host Jesse Barrientos. Jesse, welcome to the show.
Thank you very much, Dave.
How are you today?
I am fantastic.
Okay, there's a lot going on in the news in terms of divorce and family law. We might cover that a little bit in the show, just to stay topical as we try to do. But I do want to get to the majority of the questions that we received over the last several months from viewers in the local area that want to know about divorce and family law issues. So would it be all right to jump right in on that?
Let's jump right in. I've got a good one for you, Dave. It's Eric in Calumet City asks, will I have to pay spousal support if I'm only married 4 years?
Well, spousal support is known as alimony, formerly known as alimony, now called maintenance. So it has to do with paying one spouse money for support, not child support, just spousal support, one to the other. 4 years is a short-term marriage for the most part, but it's going to depend on a number of factors, Jesse. What are the incomes of the parties? What is the lifestyle that they grew accustomed to over those 4 years? What's the earning capacity of the parties? What's the standard of living that they're going to have going forward? Educational background? If everything is equal in terms of income, then no, there's not going to be spousal support. However, if you have a doctor making $250,000 a year and a spouse that's making nothing, and they've enjoyed a heck of a lifestyle based on that income, then I think it's reasonable to assume that there's going to be some spousal support for at least a short period of time.
Well, come on, we're talking 4-year marriage here.
Maybe some rehabilitative maintenance to get that person back on their feet, maybe to go back to school, to get a job, to get a trade, something. Or in lieu of maintenance, maybe there's a disproportionate share of the marital estate going to be divided. So there's a number of factors there, but you can never say for sure whether or not there's going to be maintenance or not. It's an issue that has to be litigated or pre-tried and negotiated between the parties.
And there's no magical formula that tells you if you've been married 4 years, this is what you get, or been married 2 years, or the least amount of time you're married. That's just one factor, but that has a lot to do with.
Yes, in some states there's a lot of guidance in terms of maintenance, a number of years of marriage and things like that. But in Illinois, we don't quite have that. You just have to read the statute. There's a section specifically on maintenance. It enumerates about 11 or 12 different factors that the court can take into consideration. Doesn't say they have to. They may take into consideration. But it's really a negotiated issue. If you have good counsel and your spouse has good counsel, you're going to be able to come to a meeting of the minds on that, I'm sure.
Yeah.
So,
good.
Jesse, Laura in Chicago wants to know, my spouse has a huge pension with the city of Chicago. She's been with him for 29 years. However, only married for the last 6. What is she looking at in terms of portion of that pension? 29 years together, married 6.
Well, I got good news and bad news.
Give her the good news. What's Laura going to get?
Good news is Laura's going to get divorced. That's the good news for her. Bad news is, unfortunately, she's only going to be entitled to the spousal share of his pension, which if he's had that job and he's accumulated most of his pension before the time they were married, and they were only married for 6 years, then it's only that 6-year period that she would be entitled to her spousal share. Now, what could that be? Generally, it could be 50%, and if we're only talking about a 6-year marriage, much like we were talking about the 4-year marriage, that the court certainly could give a disproportional share of that, give her more than 50%, and it would also depend on other factors as well. The courts also look at non-marital property, marital and non-marital. Generally, anything acquired during the course of the marriage is marital, generally.
Now, wait a minute. She cohabitated with him for 29 years.
It doesn't matter.
They split the marital expenses. They even have a house together that they paid for all 29 years. In her eyes, this is a long-term marriage, and she wants 50% of everything while they were together. She's in for what, a rude awakening?
She's in for a rude awakening. It's not going to happen. according to the law, it shouldn't happen because it.
Oh, he doesn't want to give it.
She hasn't been married.
He's throwing that 6 years out at her, according to her email.
Yeah. He
that he's
probably
telling
talked
her-
to a lawyer.
Yes, he said, we've only been married for 6 years. You're not entitled to anything but 6 years, and maybe not even 50% of it.
Yeah, it depends in terms of, that's an interesting issue with the house. If they bought it early on in the time they got together, because that certainly couldn't be in anticipation of marriage. There's a lot of interesting factors there, but she's not going to get what she thinks in terms of the share of his pension if they hadn't and weren't married.
So the real significant date is the date of the marriage, not the date that they were living, cohabitating together in a monogamous relationship.
That's correct in terms of those property dispositions. Yeah, it's not going to be now depending upon what judge you get. You might hit a heartstring and you might get a disproportionate share. But really, if you're just looking at kind of what the law says, hey, that's from the date that you were married.
Okay, well, let's say she gets the 6 years and she's happy with that and she's going to get 50% of it under their agreement. Talk about the mechanics of how that actually gets into her hands, because this is a pension. This isn't something that she can just go and
Right.
withdraw, correct?
That's correct. Each plan administrator has, or each plan has different rules, and so generally, the court orders what they call a QDRO, Qualified Domestic Relations Order, or QDRO, Qualified Illinois Domestic Relations Order. And what happens is, depending upon what the distribution is, that'll be laid out in the marriage settlement agreement or in the judgment. If they go to a trial and the court actually makes the award themselves and makes that adjudication. And then either of the parties' attorneys will have to draft a QDRO or a QDRO and send it in. Generally what happens, and the good way to do it, is to get the information from the plan administrator first as a guide, complete it, and then send it in for preliminary approval. After you receive the preliminary approval, then you can go ahead and have that entered and then send in the certified copy of that to the plan administrator. And then, there are various options. There could possibly be a lump sum. There could possibly be payments. It just depends on the plan. And what will happen is generally they'll break off the amount of whatever that person's going to get and put it into a separate account. And, that person could even roll it over into their own pension plan if they wanted to do that.
I've seen many cases where a litigant was awarded a percentage of the spouse's pension, profit sharing, or retirement plan, and then simply did nothing. Even though there was a court order awarding a portion to them, they didn't take action.
That's
and
dangerous.
they lost the interest.
Right. They could lose that. They're also in danger because if something happens to the other spouse, they're no longer married, and so they're going to have an issue. That's something that should be addressed probably sooner than later.
Yeah. One case in particular, and I won't give any names, but the person who was awarded the pension or profit sharing did nothing, and the ex withdrew all of the proceeds and took off, parts unknown. So when the spouse finally woke up to the fact that she should receive some of that benefit, contacted an attorney to get it done, the ex was gone, the account was gone, it was liquidated, and she was left with nothing. So you have to move quickly, or judiciously, I should say,
Right.
once you have an award on something.
Right.
So it was a big problem.
A lot of times what will happen is once the plan administrator or the plan is advised of what's going on, then they'll freeze it.
They never advised anybody.
Right.
They just, they got the award,
Didn't do
it was
anything.
part of the judgment, and they let it sit in a drawer. So, what do you got for me?
Dave Stephanie from Joliet asks, what grounds can I use if my spouse verbally abuses me, but he remains faithful? Have you ever been verbally abused, Dave?
On a daily basis in my line of work, unfortunately. But you have to fend it off and kind of handle it, try and diffuse the situation. People are struggling out there, especially in my type of work.
Mm-hmm.
The people that I talk to, Jesse, they're hurting. They're hurting financially, they're hurting emotionally. They're going through a lot of trouble, and sometimes they vent.
So I come to you, and that's what Stephanie's asking. Hey, listen, he's faithful, hasn't done anything else. He just talks to me like the Dickens, like the devil, just continues to just ride me and put me down and doesn't appreciate the things that I do.
Well, the bad news for her is she's going through this. The good news is she can get out of it. And the grounds in Illinois that provide that are mental cruelty. If he's belittling her, if he's telling her he doesn't love her, if he's making her feel worthless, and she's not doing anything to provoke this, he's just coming out and causing her all kinds of hell.
You mean you have to tell your spouse that you love them? That would be mentally abusing them? I got to
No.
kind of think about that.
No, but if you tell him, I don't love you, I
Oh,
don't care about
okay.
you, you're nothing, you mean nothing, you're worthless, you'll never be anything, you'll never find anybody else, you can't walk on your own 2 feet, that's mental cruelty. And if it's repetitive and it's unprovoked, that's one of the grounds that somebody can use.
Unprovoked. So there's a possibility that we could just be telling one side of the story, and we're getting this because I'm telling you similar kinds of things.
That's right. If you have 2 people that are mentally abusing one another,
It's
you don't
still-
have the right to use those grounds. But then you have irreconcilable differences.
Right.
We just can't agree. We can't agree to stop mentally abusing one another. So there are other grounds, and we should talk about those. There's adultery. Everyone's familiar with that. There's mental cruelty, physical cruelty, habitual drunkenness, desertion, when one party has left the whereabouts for more than a year without any cause or provocation on their part. And then, of course, irreconcilable differences. And I want to let you espouse on that subject.
Sure, reconcilable differences just simply means that you can no longer get along. So in Illinois, you have to allege grounds, one of those grounds, for the basis for your dissolution of marriage.
He won't put the seat down?
Differences. Well, yeah, it could be, but irreconcilable differences is just that you can't get along. So it's kind of it's what they call the no fault. The caveat with that is you have to be living separate and apart for a continuous period of time in excess of 2 years. However, most of that can be waived, all except for 6 months. But living separate and apart doesn't necessarily physically living separate and apart. A lot of times people will move to a guest bedroom and they'll move there for a long time. Sometimes they'll even vacate the marital residence. That's easy enough.
It's usually the basement.
Well, usually the basement or the basement, or even sometimes they'll continue to sleep in the same bed, but they'll no longer be intimate. They'll be more like roommates, and so
They'll be hanging off the edges.
hanging off the edges, and so that kind of goes toward the time. And as I said, if you don't have, you need at least 6 months that has occurred, and then you could waive the rest of it.
Yeah. I've seen cases where one client works days, the other spouse works nights.
Yeah,
They don't even pass like ships in the night because they don't even see each other.
and it works out well for them.
It works out well, but they still don't want to be together.
Yeah.
They still want to end it
Kind
and
of
move on to something that may be a little bit more rewarding.
right.
Marriage is not for everybody, Jesse, and if it's not working out and you try to fix it, the court provides irreconcilable differences for those who really just can't point a finger at the other for doing anything wrong. It just didn't work out. We can't get along.
That's exactly right. And so, once you've realized what it is, it's time to move on.
Okay. Let's talk about Darren in Lamont, which is also Cook County. Darren says, my attorney is threatening to withdraw because I can't pay his bills. What are my options going forward?
Well, let's just first talk about this. It's very important. Okay,
Yes.
there's no involuntary servitude unless somebody's agreed to represent somebody for nothing or has agreed to do that. I mean, lawyers generally are out there. They're providing a service to get paid, and so his options are to pay your attorney.
He
to
can't pay the attorney.
Make some kind of deal with him in terms of payment options, and if he can't do that, then obviously if he can't afford to pay this one, he can't afford to retain another one, then his only option is probably going to be to represent himself.
Well, he hasn't paid this one in a while, so he does have the ability to hire another attorney, but he doesn't want to get in the same situation where the bill starts to run up and he can't pay again.
Well, unfortunately, that's going to happen in any type of litigation. Things happen, there's no control over it. It depends on what the other party is going to do.
He
What
wants a
motions
pro
they're gonna
bono
bring.
lawyer, he said.
Well, then I would suggest that he call either legal aid or he call the Bar Association. There are pro bono attorneys out there. However,
He did call legal aid.
and they didn't give him, right,
Correct.
because he didn't meet the threshold because he makes over $50,000 a year.
Around that.
Right. And so while that is not really all that much when you kind of look at it, it's certainly above the poverty level. And so unfortunately, he's gonna either have to represent himself, or, which is something I never really recommend that anybody do, because they just don't know what the law is, and especially if the other party has an attorney, there's gonna be some issues.
Okay, so don't represent yourself.
There's the,
Can't pay that attorney.
right. Well, it sounds like he can pay him because he saved up some money.
He
just
can't
doesn't.
pay that attorney.
That
Maybe
attorney.
that attorney's a little excessive, so he needs to get somebody he can afford. He needs to investigate
He needs
that.
to get somebody he can afford. And also, probably what's going to happen is this attorney is most likely going to file a fee petition, and there's going to be a judgment collecting 9% interest against him at
That's
some
his
point.
fear, that the outstanding fees he's going to have to pay. So
So
can he work a payment plan with the attorney?
he can work a payment plan with the attorney. I don't know what the specifics are. He can, probably do something. I don't know if there's any property there. There are a lot of things. But here's the thing: you don't know unless you ask. Communication in everything is the key.
Yeah, it's about a $14,000 debt.
Well, he needs to ask. What stage is it in? Are they close to concluding it? Is it set for trial?
Pre-trial.
So
So he's going to need a trial attorney if they can't
if
resolve it.
if they can't resolve it. So, what are you hearing, Dave? What is the best thing to do here? Resolve it.
Resolve it, absolutely.
Yeah. All right. Lisa in Lyle asks, my spouse earns $1,000 per week, and we have one child. What's the amount of child support that I'm entitled to?
Okay, well, there's a guideline that the state of Illinois has for child support. And for one child, that would be 20% of the non-custodial party's net income. So you do the math here, $1,000 a week, 20%, it's $200 a week.
If that's his net income.
If it's his net, and if there are not any unusual deductions coming out of his pay.
Right, because people think that they could have all these exemptions, and so basically, they get a lot less than that, and that's not really your net.
Right, and sometimes they'll have other expenses, automatic payments and things like that coming out of their
Pension.
pay. Got to be careful there.
Right.
Yeah. Well, pension's valid if it's a mandatory pension.
If it's mandatory. Also, union dues, insurance, health insurance is.
But
gonna
remember,
be
the
those
20%
things.
is just a guideline.
Right.
So you have to look at other factors. For example, if you have an athlete that's making $700,000 a year, 20% is going to be excessive. So the court's going to knock that down and deviate from the guideline. But I think in a $1,000 a week situation, $200 a week, I think the court's probably going to try and stick with those guidelines.
Yeah, I think that is going to be reasonable. Now, you mentioned about deviating downward. Let's talk about deviating upward.
Yes.
What would be a reason to deviate upward?
A child with special needs is definitely a deviation upward, or any other exigent circumstances that causes a need for more income to support that child. Maybe there's an educational issue. Maybe there's extracurricular. Maybe the child is a fantastic ice skater, and the court feels that should continue, and there's a huge expense there.
Should be
The
nurtured.
court might deviate upward, but usually it's you're more likely to see a deviation downward as opposed to upward.
Right, and it's important too. You don't have to be an athlete making that kind of money a year, because there are different reasons to deviate downward. One would be, for example, if let's suppose that you have a house and it has some equity, and your agreement is that you're going to let the other person have the house, and so that's calculated into figuring in terms of support. And so, but it has to be crafted very carefully so that it's articulated in your agreement that that's specifically what it is, because child support can be generally modified at any time based upon a change in circumstances. So, but if I'm giving you $100,000 in equity in the house, we're going to get some kind of credit for that normally I would be able to have. So it could be deviated downward in an instance like that. But again, it has to be spelled out in the order as to what the original amount would be, and then why it's being deviated downwards.
Another reason to deviate that I see a lot is when one party is going to have the child for 4 days a week, the other party is going to have 3 days a week. So it's a little bit more than the traditional alternating holidays, alternating weekends. You don't have a total split custody, but you do have an arrangement where one party has the child for almost half of the time,
But
without a court order for that. So the child support isn't necessarily required to be at the statutory guideline, because the person who has visitation is providing quite a bit of the support while they're in his or her care. So that we've seen that before too.
Right. But it doesn't necessarily mean you could still have that arrangement and still pay the full amount of guideline support.
Yeah, I think most people are willing to pay as long as the money is actually being used for the child. And that's an issue too. If the spouse is taking the money and not providing the real care for the child, that's a problem.
Well, people have to understand too, there's no accounting for that. And child support goes for different types of things like a roof over your head, like the utility bills, like the cable bills, like the food, and all of those other things. So it's not just, oh, well, wait a minute, I can't believe that you spent $200, in just diapers. You got to, well, no, it goes for all those other things as well.
Right. Bonita in Cicero wants to know, Jesse, she's not legal. Will the divorce case affect my immigration status? She's worried about that.
Well,
with good reason.
If she married and she has some kind of a petition going with INS,
she does.
Then it's going to be a problem. I'm not an immigration lawyer, but there's an interplay with divorce and immigration, and unfortunately, especially in these trying times, if she does get a divorce, it is going to affect most likely her ability to be able to get her papers.
Yeah, her spouse has threatened to not cooperate with the remainder of the immigration process, mostly because he feels it was a fraudulent marriage. Well, and that she just wanted to gain access to the country, and she really didn't love him, so she's not really coming in with clean hands, is what he's alleging.
And I mean, if that's true, and that's what the immigration advocate or judge determines, then that's and that happens a lot, though, Dave.
Yeah.
It's very, very true. You talk about mail order brides and those different types of things, and people want access, and they're willing to do just about anything to get their paperwork. But yeah, that's going to be a problem for her. But here it is. It is what it is. You can't make somebody love you. You can't make somebody stay married to you, and you just have to go through it and deal with the issue.
I agree.
All right, we have Mitch in Bloomingdale. Asks, my divorce has reached the discovery phase. What on earth does that mean?
The discovery phase. Yes, that's a little bit of a misnomer. Discovery is where the parties are compelled to provide information, whether it be economic, the finances, their property, their bank accounts, their personal property. They basically have to show their hand. And then the other side has to show their hand. And they do this through either written interrogatories, requests to produce, or, in some cases, a full-out deposition. It's from that discovery phase where the attorneys can actually look and see what the parties have. Much like your hand in poker, you have to show your hand. Okay? If you have a pension, if you have a retirement account with $800,000 in it, this is the time you have to disclose it so it could be factored into a settlement.
Well, how do you know that I'm actually disclosing the things that I'm disclosing?
Well, you don't really, but you are doing it under penalty of perjury, so you're running the risk of being locked up if you're hiding something.
So in addition to perhaps getting the answers or discovery from the other side, perhaps you might want to subpoena some of those documents like bank accounts or pension statements or anything else.
Yeah, depending on what the opposition provides and what your client knows about what the other side has, then you're going to get a good idea of whether or not they're being forthcoming or not.
And people may or may not be surprised that a lot of times, generally, there's one person that's been responsible through the entire course of the marriage in terms of taking care of the bills and writing everything out, and the other person just realistically put their paycheck into the bank and it just gets taken care of. And so they really don't have any idea on what's going on. Certainly for those people out there, I just want to tell you, listen, it is something, it's something that your spouse can do and take care of and write the bills, but both of you need to know where you're at financially. And the only way that's going to happen is if both of you know what those finances are and what those expenses are. I think that's neglected way too often, and that leads to, of course, a lot of other issues like debt and perhaps even bankruptcy.
Yeah. Now, this discovery phase is typically only in a contested case. If you have an uncontested case, you might have what they call limited discovery,
right,
where the parties will voluntarily provide account information and holding information and property information so that they can come up with a quick settlement. But it's only in a real contested case where you're going to have a deposition. Deposition is a fact-finding expedition to find out what what someone has, and it maybe contradict some other information that they either provided or did not. So discovery is a difficult phase, and it's expensive, and it's tedious, and it's tough on the clients and the lawyers because they have to copy and provide all this documentation to the other side, and that takes time, and time means
money.
You got
In
it.
fact, I just I got some discovery out today, so yeah, I can certainly echo that.
okay. Andrew in Arlington Heights, right next to the racetrack.
Ah, very nice.
He says his child is going to attend college next year. I guess he's a senior in high school. He wants to know how much he's going to be responsible for in terms of tuition and expenses, and what about his ex's responsibility towards these fees?
So they've already had. Well, it depends on what the divorce decree, what the marriage settlement agreement, what the judgment says.
It said reserved according to statute 513.
Well, then if it's reserved according to statute, what's going to happen is the court. Well, first the party has to file a petition for college expenses. Now, I have to tell you that the clock only starts ticking when they file that petition. Had their original divorce decree said something into it in terms of what they were going to contribute and what they were going to pay, they could have done it retroactively. I mean, I know he's just a junior, but let's just say he
No, he's a
paid a
senior.
year. He's a senior, but let's just say he paid a year of college and then decided to do it. Then he could he could go back and get those funds retroactively if the original divorce decree provided for it. And there's case law on that. However, if it just according to statute, then what he needs to do is he needs to find out what those expenses are going to be. He files his petition. There's going to be more discovery because the key in that is to know what position either party is, how much you make, how much your ex makes.
Well, that's just it. We don't have a lot of money here. He's making 20 to 25, and his ex is making 15 to 20. So we don't have a lot of money here for college, and we don't have a lot of money to litigate.
Well, but it's interesting though, Dave, because the law says that children of divorced parents, okay, are entitled to contribution to their college expenses. That's the way it is. You don't have that with married, with kids that the parents are stayed married. So you don't have to send your kids if you're married, college. But if you're not, then you can. And everybody's expected to contribute. Generally, if you're making more, now I understand that it's a little bit different. So it sounds like he may be paying a little bit more than his ex. However, the child is also expected to contribute through grants and loans and even working as well. They have to have they have to do something to better their education as well.
Yeah, I guess his real concern is that his ex is not going to be able to have any funds available because she's supposedly just sustaining herself to provide towards any kind of college. So this kid might have to go to a small junior college or a community college initially if there's no loans available for him.
If there's nothing available, then that's what they have to see, and that's what you see a lot of kids doing, going to the junior college to get the required credits, and then after a couple of years going to one of these other colleges where those things will transfer over.
Sure. Jesse, in the final minute that we have, I want to throw in one here. This is important. Erica from Rosemont wants to know, how does she go about finding the right lawyer for her case, which is a great question.
You need to get somebody who predominantly does divorce law, who has been doing it for a long time, who's familiar with the judges and familiar with the jurisdiction, because it's very important to know who your judge is and what you're going to do. It's very important to go in and have a face-to-face and talk to that person. You have to feel comfortable because you're going to be spending a lot of time with this other person, and they have to have a good temperament. You want to also find somebody who's going to be able to explain things to you and take the time, and who's going to copy in on everything that you get. I always try to make sure that the person has the same file that I have, so that they know exactly what's going on at every stage of the litigation.
That's great advice. Jesse Barrientos, thanks for joining me.
Thank you, Dave.
You've been watching Legal Action. My name is Dave Siegel. We'll see you next time. Take care. Bye-bye.